What's up, guys? Don't mind me. I'm just posted up at a restaurant here in Santa Monica, not far from the courthouse. Just getting ready to head back at 1:30, eating a Caesar salad with some shrimp, and getting ready to update you guys on what is going on. It's a tentatively good ruling for Jay-Z, where we last left this lawsuit against Tony Buzbee. This is Jay-Z's lawsuit against the lawyer who sued him for rape in that case that's now been dismissed. Jay-Z's lawyers were in court today, continuing the hearing that they had back in February about whether the defamation and the extortion claims should move forward. And the judge's tentative ruling, we've talked about this before. If you guys go to my website, legalaffairsandtrials.com, I've got a story on how the tentative ruling was that the extortion claim was going to be thrown out. He was going to keep 3 of the 6 defamation statements under the defamation claim, throw out the extortion claim, and then the intentional infliction of emotional distress claim would survive only under the defamation claims for the 3 statements. But Jay-Z's lawyers said that they had more information they wanted to present that they thought would support the extortion claim. And that's when we saw the flurry of filings about the interview with Jane Doe, how she had said that she didn't, the Jay-Z's investigators had said, so you weren't actually assaulted by Jay-Z, and she was saying, affirming, yes. And then actually said that Tony Buzbee was the one who wanted to bring Jay-Z into it. So then Tony Buzbee turned around, his lawyers did, and filed a declaration from Jane Doe saying she stands by her claims and that she was intimidated by these investigators, etc. So there was back and forth filings about this for over a couple of weeks, and Jay-Z's lawyers wanted to take the deposition of Jane Doe and her lawyers, and Tony Buzbee, to saying that these statements about Tony acting on Tony being the one to push Jay-Z on her, that all this supports the extortion claim. So this was their finally morning in court to discuss this. Let me see here. I'm trying to pull out the tentative ruling here. It's a big 50-page ruling that is not online. I would have to take this to a FedEx or something to scan it in online. But it's it keeps the extortion claim. It's the judge saying that the new information presented by the things regarding Jane Doe is enough to move the needle on the extortion claim and keep it in place. So it's a pretty big win for him. I mean, it's still just a tentative ruling. The judge likes to hear argument. The attorneys like to argue, and it's actually coincidentally the same judge who is presiding over Soulja Boy's trial. So the hearing started at 9. They didn't actually get to the case until maybe 9:30 or something, 9:20, and heard argument for about an hour or so, and went till 10:45 actually, or 10:40 or so. But they're going to be back April 7th to discuss. So that's in 2 weeks or something. April 7th to finish the hearing. But right now the tentative ruling is obviously in Jay-Z's favor because it keeps the extortion claim, and it's still the same ruling on the defamation statements. There's 3 statements the judge wants to throw out, but 3 would be kept in here. And here my article on legalaffairsandtrials.com goes through what the actual statements are. The surviving statements are, it may not be big names at first, but we have a long list of names. And then the other statement is that Buzbee called his client in the rape lawsuit against Carter a sexual assault survivor, which Carter's defamation claim alleges reasonably understood to refer to Mr. Carter as the perpetrator of the alleged assault. And then the third statement that the judge says can survive under the defamation claim is that Buzbee was paraphrased by TMZ as saying, not ruling out filing rape charges against Mr. Carter, Jay-Z, with New York authorities. And what happens next is up to my client. It's her case. If she decides to do, you will find out in due course. TMZ also said Jay-Z's rape accuser might take the music mogul's advice and file a criminal complaint against him. The after slapping him with a civil suit alleging sexual assault, according to her attorney, Tony Buzbee. So these are the statements, and this didn't change in the new tentative ruling. The judge is allowing those to move forward under the defamation claim. The statements he plans to dismiss are Buzbee telling Stephen Smith on October 2nd, "I want to make sure I capture a wide net and capture everybody involved, and that's what I'm trying to do." I mean, he goes on here. It's a pretty long statement, but the judge ruled that that's not going to survive the dismissal motion. Same with the statement Buzbee told Chris Hansen that facilitators committed misconduct, and he claimed that they should be prosecuted underneath the jail. "I expect the Combs indictment and the charges in the indictment will grow. I expect other people will be implicated." So I think that, like I say, I think we're only seeing the tip of the iceberg here. And that's one of the statements that the judge ruled is going to be dismissed, is under the defamation claim. And then the third statement is him telling Sean Atwood on a podcast, there are going to be some people named in these cases that are going to raise eyebrows. If you were a bank and you were somehow facilitating this by allowing, hundreds and hundreds of thousands of dollars of cash to be withdrawn to be used for various things, or you were some sort of pharmacy that ordered large volumes of particular drugs were being purchased, or maybe you were a hotel or a club, or this type of activity was taking place, you're going to be named. So again, those are the three statements that Epstein said do not survive the dismissal motion for defamation. So, tentatively, back in February, the tentative ruling was to allow the three previous statements to survive under defamation. But it overall wasn't the best ruling for Jay-Z, because the throwing out of the extortion claim would have really kind of gutted the case. I mean, these three defamation statements could survive, but the idea that you would actually put that to a jury, it's not enough for a jury trial. I mean, technically there could be a jury trial, but you got to imagine, what would the damages be on that? If a jury did rule that these three previous statements right here were defamatory, I mean, this could seriously end up being like a dollar damages case. It's just not a good case without the extortion claim. But them tentatively getting the extortion claim back in based on Buzbee's or on Mark Epstein's ruling today is a very, very good thing for them. Let me go back to my my thread here. Yeah. So again, I can't. I wish I could pull this all up, put it online for you guys right now, but I just got it here at the lunch table with me going over it. And the first half of it is similar to what I read before. And actually the tentative from February is included in my legalaffairsandtrials.com article. It's, he goes through the same analysis that he did for the defamation claims, but then things change when he gets to the new evidence regarding the extortion claim. It's on like page 50-page ruling, and he gets into the new evidence on like page 37 or 38 or something. But he says that it says here. Yeah, you see it? It says, at the last hearing, Carter's counsel made a surprise announcement. He stated that he had learned of new evidence. At the hearing, he could not divulge what the evidence was, and that is what gave rise to the continuance. Carter has since submitted supplemental declarations that he believes bolsters his claims as to both extortion and defamation. In response, defendants submitted declarations, and finally, Carter submitted supplemental declaration. The court sets forth now. So this is the new evidence that in the end the judge is saying is going to save the extortion claim. And it's the statements from Jane Doe. It's the investigators going to Jane Doe's house in Alabama and talking to her, surreptitiously recording her, which isn't illegal in Alabama. They were able to record her without her permission there. It would be illegal in California. And there was kind of some talk in court today that the fact that it's wanting to be used as evidence in a California court case could be some kind of legal issue that you'd see in like an appellate case over this or something. But it wasn't really discussed much today. But what was discussed, and let me pull up the thread here, was who who are the investigators who talked to Jane Doe and who do they work with, who hired them? Because Buzbee's lawyers, one of them is Camille Vasquez, who represented Johnny Depp in his defamation case against Amber Heard. She brought up that, and I've heard this, I mean, covering lawyers and covering stuff in court for years, I'm familiar with the concept that if somebody's represented by an attorney, it's considered unethical. It's an ethical violation for an attorney to contact that person and try to talk to that person without going through their lawyer. And Busbee's lawyers were making the point that that appears to be what Jay-Z did here when these investigators went to contact her. But the Quinn Emanuel lawyers who represent Jay-Z made it clear today that they are not the ones who hired the investigators to go talk to Jane Doe. If they had, it would be an ethical problem for them because they're licensed lawyers who aren't supposed to be like contacting anyone represented by counsel. But they were saying that they have no connection to these investigators. And at first, it's Robert Schwartz from Quinn Emanuel who was in court. He said that he thought Rock Nation hired them, but then later on he went and said that he misspoke, and it was just somebody around Jay-Z, like an assistant to Jay-Z, who went out and hired them. And Epstein was making the point that Jay-Z is all over this, like regardless of what happened, or regardless of what his direct connection is or not. But again, as people who are following my thread in court today saw, his tentative ruling was to strike the extortion claim and 3 of the 6 statements brought under the defamation claim. That was the tentative from February. But so this led to the releasing of the transcript, the audio of the interview with the accuser, and Judge Epstein. What time did he start here on the case? 9:30. He said, based on Buzbee's lawyer's comments just now, remember at that time I had not seen the 50-page tentative ruling that they were all talking about. But it was obvious from Buzbee's lawyer's comments that Epstein's tentative was to accept the statements from Jane Doe to Jay-Z's investigator. So that right there that's not a good sign for Buzbee that the lawyer or that the judge is going to accept those and consider them in deciding the motion. And Buzbee's lawyer said that the statements were obtained through a manner that is, quote, to be blunt, grossly improper. And he said that the transcript of Jay-Z's investigator's interview with the woman indicates that these are intimidating circumstances. And we've seen that before. I went over it in another live, went over the details of how they approached her and talked to her. And they threatened to publicly identify her if she didn't cooperate. And he says the interview was basically an attempt to circumvent attorney-client privilege. And Epstein, who has quite a background, he has a family connections in the judiciary. His dad was a pretty esteemed appellate justice who died a couple of years ago now. But he mentioned the crime fraud exception when responding to this, which kind of perked my ears because one exception to attorney-client privilege and a way to pierce attorney-client privilege is to find that the communications were done in furtherance of a crime or a fraud. And we saw that in the January 6th case regarding John Eastman. We've seen a lot of rulings about crime fraud exceptions. So it definitely piqued my ears when the judge mentioned that. But the discussion, like I said, it was about whether who did the investigators actually work for when they approached Jane Doe. And Epstein was saying, and he made the point that while lawyers can't talk to her if she has a lawyer, other people can. And he said Carter, meaning Jay-Z's legal name, Sean Carter, does have the ability. He has like the legal right or ethical right to approach her and ask her questions. But he said, I'm not suggesting you do this. Please don't have him do this. But his point was that the ethical restraints against lawyers who are contacting people who are represented by clients, those don't apply to non-lawyers. So like Jay-Z would have been fine to contact her, and so would his investigators. And that was the point here, is that the investigators weren't working with the lawyers. They were separate. So Robert Schwartz says, nobody at my law firm hired these investigators, and no one knew they were being hired. Mr. Carter is free if he had wanted to knock on that door or hire an investigator to contact them. He said that is not an ethical violation in California. Judge says he doesn't want them disposed. no depositions yet for Jane Doe and Tony Buzbee, and he gets into that more in the ruling, the tentative ruling about why that is. But one thing he's concerned about is the transcript of her deposition leaking to the press. He said he noted a few things that a lot of this case just seems to be written for the press and that kind of thing. Somebody asked, they just went to her home. I mean, investigators, it would not be that hard to identify who she is. I bet they focused on the fact that she lived in Rochester for years and then moved to Alabama. And I think just through a public record search or an advanced public record search on that, you could narrow it down to people who used to live in Rochester during that time and now live in Alabama. You could probably narrow it down to a few dozen people or whatever, and then you go from there. Start looking up the people and identifying details, and it wouldn't be that hard to identify who she is. So, they must have just gotten her address through old-fashioned investigation. But hey, Jayla, thanks for saying hi. Thanks to everybody for tuning in. Give me a like. Give me a like, comment. I'm trying to juice the algorithm for me. I had a lot of stuff going on, so I wasn't really online for a couple of weeks, but I'm trying to get back into it. Hey, Meghann, you said this was a good day for Jay-Z. So did they throw it out? No, so this is his lawsuit. So he would not want the lawsuit thrown out. He's suing Tony Buzbee. So he doesn't want the lawsuit thrown out. It's Tony Buzbee who wants the lawsuit thrown out. And back in February, the judge was going to throw out the extortion claim. But the judge's ruling today, his tentative ruling, which is not final, is that this new information presented by Jay-Z's lawyers about the woman's statements and questions about who actually brought up Jay-Z, that kind of thing. He said that better supports the extortion claim, so he thinks he could salvage it. Ruling isn't final yet. It's not going to be final until after April 7th. But I've got the tentative ruling here where he's going through the new evidence, but it actually point blank says the new evidence from Carter, if taken at face value, changes a lot. It says, remember that Carter's burden is not to show that he will win, just to show that there is a disputed issue of material fact. So for defendants to defeat the motion in the teeth of this new evidence, because they must show that the evidence ought not be considered at all. The court therefore first discusses the evidentiary issue, whether the evidence should be considered. Because as the astute reader will have gathered by now, this court is not inclined to disregard the evidence out of hand. That is not an easy decision. That is not as easy a decision as might first appear. The judge, you can tell, is a law nerd for sure. He gets into the weeds on all of this stuff. So I think Jay-Z, if this ever gets to depositions, I see somebody asking if Jay-Z would have to testify at some point. If this does get to depositions, then yeah, they would take his deposition. They would take Tony Buzbee's deposition. They would take Jane Doe's deposition. All that could happen. And the judge writes about that, about how all those people could have their depositions taken. But he thinks it's too early. He doesn't feel the need to allow any kind of depositions with Tony Buzbee or Jane Doe right now. Let's see if I can get to some statements about... Oh, there's an interesting footnote about Jane Doe being anonymous. He actually says in here, in all cases, there is the problem that Doe remains anonymous. The court will assume that both parties are or would be willing to identify Doe in camera. And in camera means like in chambers with him, like private just to the judge. The court does have some concern as to whether it can consider any of this without some assurance that Doe is really the person she purports to be. And defendant's declaration from Doe is of questionable value given that the signature does not name a name. And naming Doe in camera hardly seems to put Doe's identity at risk. It appears that every party in the courtroom knows who Doe is. Letting the court in on that information will not add material to any need for secrecy. Having said that, at least on this record, the court is confident that it is proper for her identity not to be in the public record. She is allegedly the victim of sexual abuse as a minor. Indeed, as discussed below, nothing in Carter's submission creates any doubt as it would relate to the alleged rape by Diddy. The court believes that allowing her to remain anonymous in this proceeding easily satisfies the relevant tests. So that was an interesting footnote. He wants to know who she is, but just for his own confirmation purposes, the judge, but he's not going to identify her in court. He's talking about the tape of Jane Doe. He says the recording is at least arguably legally obtained. The investigator's statements as to the words Doe uttered are not hearsay, only the truth of Doe's words. But the fact that the statements are on tape does have indirect significance. At some point, if this case goes forward, Doe will almost certainly be deposed. That's what the judge says here. Because the statements are untaped, Doe will likely not be able to simply deny having made the statements and testify that the investigators are not telling the truth. Rather, Doe will have to confront her statements to the investigators as made, wear them with the defense with the statements in her declaration. What will happen then is frankly anyone's guess, but the court is not prepared to say that one reasonable outcome could be that Doe ultimately confirms that her statements to the investigators were true. And when coupled with the potential that the statement is admissible as a statement against interest, it is hard to say that the investigators' declarations are of zero weight. So it's like, okay, the ruling is really, it's wrong. But the court focuses on the admissibility of the declarations for a reason. The transcript of the Alabama recording is not certified. The court has read the transcript, but views it more as corroborating, but ultimately unnecessary evidence for the purposes of this motion. As detailed above, the transcript's importance will morph as the case proceeds. But for present purposes, the Butler and Henderson declarations are sufficient and admissible, and the court does not rely on transcripts for those merits. Those are the investigators who actually went to Alabama and met with Jane and interviewed her. It says the third option is to have Doe deposed. The court is not inclined to allow this at this time. It says the court is quite concerned that once the discovery door opens even a crack, it will be hard to keep it from opening entirely. Further, that deposition will need to be subject to a protective order, at least for the time being. Doe is not a party to this instant litigation, and she states that she is a victim of a horrible crime when she was a youth. When she apparently denied that Carter had anything to do with it to the investigators, she never denied the event with Diddy. She has adhered to that throughout. And the judge writes, the victim of a crime, little downtown action here. Santa Monica sucks, by the way. As somebody who lived in South Orange County and knows a real beach town, Santa Monica sucks. It's just a bunch of rich people. But anyway, says the victim of a crime, especially a heinous one like this one, ought to be given some consideration by the court, and this court will do so. And it says, and things have a way of getting out. This court, frankly, lacks complete confidence that the deposition transcript will not find its way to the press. There are too many examples of that sort of thing happening in litigation. The court is not saying it has happened in this case, but one need not search the press archives very long to find instances in other cases where it has happened. So, Mrs. Carter also asked to take Buzbee's deposition. The court will not grant that request. The court has no confidence that his deposition will be narrow or narrowly tailored. It is exactly the sort of thing that the legislators sought to bar when it passed the SMS statute. That's what he's operating under right now for dismissal. If the case goes forward, Buzbee will almost certainly be deposed, but not today. So that's kind of interesting here. Thanks for tuning in, guys. I think I'm going to do a live later with Mel. I'm not a lawyer, but she's here too. So, get off camera for a bit. I gotta eat my salad and then get back to court here for more Soulja Boy testimony. because Soulja Boy is on trial in his civil case for sexual assault, kidnapping, and the plaintiff is being cross-examined right now. The woman who's accusing him, and Soulja Boy was actually in court for a little bit for the Diddy Jay-Z case discussion. I don't know if he had any idea like what the case was about, but he definitely heard a lot of discussions about Jay-Z in there. Somebody asked if Buzbee was in court. No, he wasn't. He's got lawyers who are working for him. So no Buzbee, no Jay-Z, just the lawyers and the reporters. But thanks for tuning in, guys. Give me a like, give me a subscribe or something. I gotta duck off camera here to finish my salad, but stay with me here. I'll be back. All right, what's up? So I just settled up here in Santa Monica and I'm going to head back to the courthouse. The Jay-Z Tony Buzbee stuff is over for today. Again, we're not going to have a final ruling. The tentative ruling is very good for Jay-Z. They're going to keep the extortion claim. They said that the statements that they brought up from Jane Doe have changed the equation, and that the extortion claim is tentatively going to be kept. However, the ruling is not final. They're going to be back on April 7th to continue arguing, and we might get a final ruling then. So I see somebody asking, how was it dismissed with prejudice if Buzbee withdrew the lawsuit himself? Buzbee asked for it to be dismissed with prejudice. So that's how that happened. Yeah, and I think it's safe to say that he just thought he'd get easy, quick settlements from this stuff, and this stuff is kind of blowing up on him for sure. But courthouse is not far away. It's like a 10-minute walk from here. So I'm gonna head back there. You guys like my eyes? They're looking good. I got some work done on my eyes. I don't have my right eye turning in like it did. But yeah, so I will try to give you guys an update later on. But subscribe to my Substack. I'm going to be sending out something on legalaffairsandtrials.com that has everything. It'll have the tentative ruling in it. It'll have everything. So give me a subscription and support me. Thank you guys so much. I'll see you later.